Jason Adam Jensen Petitioner. In the Supreme Court State of Arizona. In the matter of petition to amend Rule Number 122, Rules of the Supreme Court of Arizona, TO establish a presumption of public recording, broadcast, and archival of court proceedings. Supreme Court Number R-26-0051, expedited consideration requested. Petitioner Jason Adam Jensen, appearing pro se, respectfully petitions this court pursuant to Rule 28, Rules of the Supreme Court of Arizona, to amend Rule 122, Use of Recording Devices in a Courtroom, to replace its current discretionary, request-based structure with a presumption of public recording, broadcast, and permanent archival of court proceedings, subject to narrow, on-the-record exceptions. This petition is filed as a companion and counter-proposal to the pending petition in R-25-0031, which proposes to broaden judicial power to restrict recording and broadcasting of court proceedings, and which has been referred to the Task Force on Rules of the Supreme Court of Arizona for further review ahead of the court's August 2026 rules agenda. This petition is organized around a single governing principle. Judicial authority rests on the appearance of just authority, not on its bare assertion. Where that appearance is placed permanently beyond the public's ability to test it, the underlying authority becomes indistinguishable, from the public's vantage point, from judgment backed by nothing but words. Examples offered throughout this petition, including matters in which the petitioner has been personally involved, are offered for this purpose alone. They are not offered to relitigate the merits of any case, to assert the guilt or innocence of any party, or to ask this court to make findings about disputed facts. They are offered because, whatever their ultimate resolution, the conditions under which they proceeded were not visible to the public in any meaningful sense while they occurred, and that invisibility, standing alone, is the harm this petition asks the court to address. The appearance of justice is the foundation of judicial authority. The proposition that courts require the appearance of just authority, and not merely its assertion, is not a rhetorical device. It is settled law. In Offat v. United States, 348 U.S. 11, 14, 1954, the United States Supreme Court held that justice must satisfy the appearance of justice, a standard the court has applied ever since as an independent constitutional concern, distinct from whether any particular proceeding was, in fact, conducted fairly. The same principle is codified as the operative disciplinary standard governing judges themselves. The Arizona Code of Judicial Conduct, like its counterparts nationwide, does not confine its concern to actual impropriety, but expressly reaches the appearance of impropriety as an independently sanctionable condition. A judge may be disciplined for conduct that merely appears compromised, whether or not any compromise in fact occurred. If the law holds individual judges to that standard, the institution as a whole can claim no lesser one for itself. This is not a semantic point. It is the only coherent account of why judicial authority commands obedience at all. A court's power does not rest on physical force. It rests on the willingness of litigants, law enforcement, and the public to treat its judgments as binding. That willingness is not generated by the fact of a proceeding having occurred, nor by the accuracy of its outcome as measured after the fact. It is generated by the public's ongoing ability to observe that proceedings are conducted the way they are supposed to be conducted. Where that observability is absent, the public is asked to supply the appearance of justice on faith, and an institution that must be taken on faith rather than observed does not possess authority in any sense distinguishable from a private actor issuing directives backed by nothing but its own say-so. This is precisely the design point the framers themselves identified when they explained why the judiciary needed public confidence merely to function as a court at all. Defending the proposed judiciary in Federalist No. 78, Alexander Hamilton observed that the courts have no influence over either the sword or the purse, no direction of the executive's force or the legislature's resources, and concluded that the judiciary may truly be said to have neither force nor will, but merely judgment. a branch of government that possesses only judgment, and neither force nor will of its own, has nothing to compel compliance with its rulings beyond the public's willingness to treat those rulings as legitimate. On Hamilton's own account of what a court is, words issued by an institution the public no longer trusts are not diminished law, they are merely words. Arizona's own courts have reached the identical conclusion when policing their own membership, ordering the removal of a sitting justice of the peace for willful misconduct. The Arizona Supreme Court held that removal was necessary to give citizens confidence in the integrity of the judicial system, not principally to redress the injury the misconduct caused any particular litigant, but to preserve the public confidence on which the judiciary's authority as an institution depends. In Re Lerona, 178 Arizona, 562, 875 P2D 795, 1994. That is the same asset this petition asks the court to protect, and the same logic, recently and independently reached by the United States Supreme Court in the plea bargaining context discussed in Section 11 below, runs through this petition from beginning to end. An institution whose power is merely judgment has nothing else of value to spend, and Rule 122's current structure spends that asset down by keeping the public from ever observing how the judgment was reached in the first place. This principle governs the remainder of this petition. What follows is not a claim that any specific outcome was wrong, or that any specific official acted in bad faith. Those are questions for the tribunals in which they properly arise, and this petition does not ask this court to resolve them. What follows is a demonstration that Rule 122's current structure removes, as a matter of routine practice, the public's ability to test whether the appearance of justice was maintained in the ordinary course of Arizona's courts, and that this removal is itself the injury with which this petition is concerned. IA. The pace the law must now keep, and the boundary of the authority this petition asks the court to exercise. Justice Oliver Wendell Holmes gave the legal profession its most durable account of what a court, or a lawyer advising a client, is actually doing when it applies the law, not deducing an answer from fixed premises, but predicting where the law is going and getting there first. The prophecies of what the courts will do in fact, he wrote, and nothing more pretentious, are what I mean by the law. Oliver Wendell Holmes, Jr., The Path of the Law, 10 Harv. L. Reverend 457, 461, 1897. He made the same point at greater length 20 years earlier, opening the common law with the observation that the life of the law has not been logic, it has been experience, and that the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. O. W. Holmes, Jr., The Common Law 1, 1881. The petitioner submits that this account carries an assumption Holmes never had reason to examine, because in his lifetime it did not need examining, that the felt necessities of the time change at the pace of a generation, or at least of years, giving the common law's characteristically slow, case-by-case absorption of new necessity time enough to keep up. That assumption is the premise, not the conclusion, of Holmes's theory. And this petition's sections vi through 8a below have already documented what happens when the premise fails. Live streaming infrastructure that took the federal courts 3 years merely to pilot, deployed instead in a single afternoon by individual state court judges on their own initiative. Artificial intelligence tools that reshape a field's working method within a single year rather than a single generation. A surveillance apparatus that went from experimental to statewide in less time than this rulemaking process typically takes to run its course. If Holmes was right that law's task is to track the felt necessities of the time, then a court applying his own method honestly today must track their velocity as well as their content, and the petitioner submits that the necessity felt at present is not simply for different rules, but for a different pace of making them. Holmes's other great observation belongs here as well, not as ornament but as method. Even a dog distinguishes between being stumbled over and being kicked. O. W. Holmes, Jr., The Common Law 3, 1881. Holmes's point was that law calibrates its response to intent, not merely to outcome, and that the distinction is one even the least sophisticated observer can draw. The public asked to accept Rule 122's current structure, or the further restriction the task force petition would add, is drawing exactly that distinction, and it is entitled to a closure or a restriction rooted in a genuine, case-specific need reads as an accident, a stumble. A closure or a restriction that recurs as the default, that requires the public to ask permission before it may do what it could otherwise do unasked, reads as something else. Section I above explains why the appearance of justice is itself an independent constitutional concern, distinct from whether any particular decision was correct. This is the mechanism by which that appearance is actually formed. The public does not need a legal education to tell the difference. It only needs, as Holmes's dog needed, to notice the pattern. These observations bear on a question more basic than what Rule 122 should say: what authority this court is actually exercising when it says it. The petitioner submits that a court does not have freestanding authority to exercise law as such. Law has authority only instrumentally, in service of maintaining the political community in a condition of both peace and tranquility, and those are not the same condition. Peace is the mere absence of open conflict. Tranquility is the absence of the desire to be in conflict, the condition in which the governed accept the terms on which they are governed, not merely tolerate them. A polity can be at peace while being nowhere near tranquil, and the petitioner submits that peace sustained without tranquility is not a stable achievement of law. It is a suppressed conflict, held in place by inertia or force rather than by consent, waiting for an occasion to resume. Measured against that standard, the existence of this petition, filed in direct opposition to R-25-0051 and the task force petition over the same rule, is not incidental to the question before the court. It is evidence bearing directly on it, genuine, structured disagreement over the basic terms of public access to the courts, serious enough that it requires this court's rulemaking authority to resolve rather than working itself out through ordinary practice, is what an absence of tranquility looks like from the inside. Magna Carta is the founding illustration of exactly this boundary, and its history is worth stating precisely rather than invoking loosely. It was not a grant of rights offered by a sovereign secure in his own legitimacy. It was extracted from King John in June 1215 by barons who had already taken up arms against him, occupied London by force, and compelled his seal at Runnymede as the price of ending open rebellion. First Barons' War, 1215 to 1217. Its enforcement mechanism, the security clause, went further than merely limiting the king's power. It established a standing council of 25 barons empowered to seize the king's own castles and possessions if he broke faith with the charter, a clause that, in the words of one standard historical account, in effect, authorized his subjects to declare war on their king. The lesson the petitioner draws from that history is not the familiar one, that the sovereign is bound by law. It is the deeper one Magna Carta's own origin demonstrates. A sovereign that finds itself in open conflict with the very people it governs has already exceeded whatever authority it can legitimately claim, because legitimate authority is constituted by tranquility and ends where tranquility ends. What remains past that point is not authority being exercised, it is position being held. The petitioner does not suggest that Rule 122 or its proposed amendments approach anything resembling the crisis of 1215. The point is narrower and more practical. The measure of whether this court's rulemaking remains within its legitimate authority is not whether a rule can be written and enforced, but whether it is accepted. And acceptance is precisely the thing competing petitions on the same question demonstrate is not yet present. This petition asks the court to resolve that absence not by adding another layer of discretionary control, which is what R-25-0031 and the task force petition would do, but by adopting the presumptive openness that sections 3a through x below show is both Arizona's own doctrinal tradition and the only structure capable of producing the tranquility, not merely the peace, that gives this court's judgments the force section I describes. 2. Statement of the issue. Rule 122 currently treats electronic and photographic coverage of public judicial proceedings as an exception granted at the discretion of the presiding judge, upon advance request, subject to findings that may justify denial. This structure inverts the presumption required by Article 2, Section 11 of the Arizona Constitution, which commands that justice shall be administered openly, and by the open courts doctrine articulated in Richmond Newspapers, Inc. v. Virginia, 448 U.S. 555, 1980. Under that doctrine, public access to judicial proceedings is the default. Closure or restriction is the narrow, disfavored exception requiring specific justification on the record. Rule 122 currently operates in reverse. Recording is the exception, and the burden rests on the public, the press, or a party to obtain permission rather than on the state to justify restriction. This petition asks the court to correct that inversion, not merely for the benefit of professional media, but for the public generally, given that the infrastructure necessary to accomplish presumptive public access already exists within the Arizona judicial branch, as detailed in Section 3 below. 3. The doctrinal basis for a presumption of openness. The legitimacy of judicial authority in the United States has never rested on unilateral decree. It rests on the consent of the governed, exercised through the public's ability to observe how that authority is used. In Richmond Newspapers, the United States Supreme Court traced the presumption of open trials to a practice of ancient origin, predating the adoption of the Constitution itself, and held that the right of the public to attend criminal trials is implicit in the guarantees of the First Amendment. 448 U.S. at 564-73. The court reasoned that open proceedings serve not only the interests of the accused, but the structural function of permitting the public to see that established procedures are being followed and that deviations will become known, a function that cannot be performed by a public that is nominally permitted to attend, but functionally unable to do so. Arizona's constitutional text is, on its face, more demanding than the federal floor. Article 2, Section 11 does not merely tolerate public access. It commands that justice shall be administered openly. A rule structure that makes public visual and audio access to judicial proceedings the exception, granted upon request and subject to denial, does not implement that command. It manages around it. Openness in this sense is not a courtesy extended by the judiciary to the public. It is the condition precedent for the judiciary's claim to authority at all. An institution that asks to be trusted while remaining substantially unobserved is not exercising open justice. It is asking for deference on faith, in an era in which no other public institution is any longer extended that deference. 3a. Arizona's own doctrine, not merely federal law, already compels this result. The doctrinal foundation described in Section 3 above rests substantially on federal authority and on Arizona's own constitutional text. It does not need to rest there alone. Arizona's own courts, construing Arizona's own common law independent of Richmond Newspapers, have reached the same conclusion this petition urges, in one instance nearly a decade before the United States Supreme Court did, and on grounds broader than the First Amendment alone. In Rydenor v. Schwartz, 179 Arizona, 875 P2D 1306, 1308, 1994, the Arizona Supreme Court held that the public possesses a constitutional and common law right of access to observe court proceedings. The court did not derive that right solely from the First Amendment or from Article 2, Section 11. It recognized an independent common law right of access, standing on its own footing and surviving even where a purely constitutional claim might not. A rule structure that treats public observation as a matter of administrative grace is difficult to reconcile with a right Arizona's own courts have already located in the common law itself. Arizona reached this conclusion before it was fashionable to do so. In Phoenix Newspapers, Inc. vs. Jennings, 107 Arizona. 557, 561, 490 P2D 563, 567, 1971, 9 years before Richmond Newspapers, Inc. vs. Virginia, 448 U.S. 555, 1980. The federal case Section 3 above principally relies upon. The Arizona Supreme Court wrote that democracy blooms where the public is informed and stagnates where secrecy prevails, and held that a court proceeding may be closed only where there is a clear, present threat to the due administration of justice or one which appeals primarily to the morbid and prurient. Id. Arizona was not a follower of the national trend toward open courts doctrine that Richmond Newspapers would later announce for the federal courts. On this question, Arizona arrived first. That commitment did not begin in 1971 either. In Arizona Newspapers, Asin, Inc. vs. Superior Court, 143 Arizona. 560, 564, 694 P2D 1174, 1178, 1985. The Arizona Supreme Court observed that this state has always favored open government and an informed citizenry, tracing the commitment to Arizona's public records law first enacted in 1901, 11 years before statehood, during the territorial period. The Court of Appeals reaffirmed the same lineage in Phoenix Newspapers, Inc. vs. Keegan, 201 Arizona, 344, 351, 35 P3D 105, 112, App. 2001, confirming that this is a continuous thread in Arizona law rather than an isolated pronouncement confined to a single decade or a single court. Read together, Rydenor, Jennings, and Arizona Newspapers, Asin describe an unbroken commitment to open proceedings running from Arizona's territorial period, through statehood, through 1971 and 1985 and 1994, entirely independent of whatever the federal courts required at any given point along that timeline. Rule 122's current discretionary, request-based structure is accordingly not merely out of step with a national trend this petition asks Arizona to join. The petitioner submits that it is out of step with Arizona's own doctrine, on Arizona's own terms, measured against Arizona's own precedent. This court is not being asked to import an innovation from outside jurisdictions. It is being asked to bring Rule 122 back into alignment with what Arizona's own courts have already held, repeatedly, for over a century. IV. A written record preserves what was said. It does not preserve how. Arizona's existing public records regime already makes most court filings, transcripts, and docket entries available to a member of the public willing to request them. If openness required nothing more than access to the words spoken and written in a proceeding, that regime would largely satisfy it. It does not, and the reason is well established in the law's own treatment of live testimony. Courts have long recognized that demeanor, tone, hesitation, effect, the manner in which a statement is delivered, carries information that a transcript cannot capture and that materially affects how a statement should be understood. This is not a novel or contested proposition. It is the settled basis on which appellate courts defer to a trial court's credibility determinations rather than reviewing them de novo from the cold record, precisely because the trial court observed something the appellate court, reading only a transcript, cannot, the witness as the witness actually appeared while speaking. If a court of record itself treats demeanor as indispensable to accurately understanding testimony, the public cannot be told that a transcript is an adequate substitute for the same information when the question is not appellate review, but whether the public can meaningfully assess the appearance of justice described in Section I. Whether a witness delivered a statement with visible distress or with none, whether an officer's tone in a recorded exchange was measured or contemptuous, whether a complainant's hesitation in answering a question reflected genuine uncertainty or reluctance. These are not incidental details. They are frequently the entire basis on which a reasonable observer would evaluate whether a proceeding was conducted fairly, and none of them survive translation into a written transcript. A rule structure that treats the existence of a paper record as sufficient public access, while leaving audio and video capture to the same discretionary, request-based mechanism this petition challenges, satisfies only the informational half of the constitutional openness requirement and leaves its evidentiary half, the half that actually permits the public to judge appearance rather than merely content, entirely optional. V. Factual predicate. The infrastructure already exists. This petition does not ask the court or the administrative office of the courts, AOC, to build new capability. It asks the court to extend, downward through the trial courts, infrastructure that the judicial branch already operates. The AOC currently maintains live streaming video and a permanent public archive of Arizona Supreme Court oral arguments. This practice has been in place for years and is treated by the court itself as unremarkable, a routine feature of how the Supreme Court conducts its own public business. Separately, the judicial branch's response to the COVID-19 pandemic demonstrated that audio-visual infrastructure adequate to this petition's request already exists at every level of the Arizona court system. Between May 2020 and August 2021 alone, Arizona court employees held 19,621 Zoom meetings involving 217,947 participants, using approximately 200 Zoom licenses procured statewide for this purpose, with more than 90% of surveyed courts reporting use of a technology-based hearing platform by May 2021. The distinction this petition draws is not one of hardware but of architecture and purpose. The remote hearing platforms currently in use were built as access tools, permitting a fixed, credentialed list of participants to join a session that is, by design, ephemeral and not publicly archived. What this petition requests is the extension of the Supreme Court's own existing model, automated capture routed to a permanent, searchable, public archive, to the trial court level, where the volume of proceedings and the public's actual contact with state power is greatest. The marginal technical and financial burden of this extension is modest precisely because the underlying infrastructure, procurement relationships, and institutional experience already exist. Vi. Other states already operate courts on the presumption this petition proposes. This petition does not ask this court to adopt an untested or unprecedented model. Multiple states already operate their trial courts on a presumption of public live streaming as a matter of routine practice, not exception. Wisconsin presents the most directly comparable example. Following a 2020 administrative directive from the Director of State Courts, approximately 70 Wisconsin Circuit Court branches across 23 counties established dedicated YouTube channels for live streaming public proceedings, with the explicit, stated goal of making all of the state's circuit court branches capable of using the technology to livestream public proceedings. That infrastructure remains active today. The Wisconsin court system's website maintains a standing live stream courts directory, organized by judge and by courtroom, and the Wisconsin Supreme Court itself continues to livestream its oral arguments and rules petition hearings as a matter of course, with a public hearing on a pending rules petition live-streamed as recently as March 2026. Wisconsin's Director of State Courts has described the rationale in terms directly applicable here. The technology allows courts to continue carrying out their vital work, while ensuring more people than ever are readily able to observe live circuit court proceedings. Wisconsin is not alone. Michigan's Supreme Court posts live proceedings on YouTube and maintains a public archive of them afterward. New Jersey's court system operates a public streaming portal for its Supreme Court and appellate division sessions. At the trial court level, individual circuits in states including Florida stream courtroom proceedings by judge and by courtroom as a standing practice, publicly accessible through each court's own website. California's Yolo County Superior Court, among others, offers full video and/or audio of court proceedings to the public via live streaming of hearings, as a stated policy, subject only to exclusions for confidential proceedings, the same category of narrow, enumerated exception this petition's proposed rule text incorporates in Section 19 below. The federal appellate courts provide the most directly instructive example, because they demonstrate that presumptive public broadcast is fully compatible with the ordinary business of a busy, high-volume appellate court. Since December 2013, the United States Court of Appeals for the Ninth Circuit, the federal circuit that includes Arizona, has live-streamed all oral arguments via YouTube as standing policy, not by case-by-case request. The court's own public guidance states plainly that recordings are available to the public unless the hearing has been ordered sealed, and further that no limitations are placed on the use of these live-streamed or recorded proceedings. The presumptively public, freely reusable model this petition's proposed rule text adopts. Public interest in the resulting archive has been substantial. Analysis cited in comparable advocacy before other federal circuits found that Ninth Circuit argument recordings are typically accessed dozens of times within months of posting, and frequently hundreds of times in cases of public interest. The Massachusetts Supreme Judicial Court, the California Supreme Court, the Florida Supreme Court, and the New York Court of Appeals, the last of which broadcasts live video of every argument, in both civil and criminal matters, as a matter of course across the Court of Appeals and all four appellate divisions, round out a group of jurisdictions in which this petition's model is not aspirational, but already the daily operating reality of appellate justice. Even the federal courts, ordinarily the most restrictive tier with respect to camera access, piloted audio live streaming of civil proceedings in district and bankruptcy courts nationwide from 2020 through 2023 under authorization of the Judicial Conference of the United States, and its Court Administration and Case Management Committee reported that the pilot revealed that there were not any major administrative or technical challenges for using live streaming technology.
Well, I guess it just stopped doing that. Live streaming technology, huh? Okie dokie. What do you think? Just pause and start it up? Well, ain't that a thing? Just leave me hanging here. Why don't you? Why don't you?
This sitting judge in
Wow. Trippy.
the Southern District of Ohio, among other participating districts, streamed eligible civil proceedings live on the court's own YouTube channel, with recordings retained for public playback for up to a year.
Gonna have to change this back to a basic. Huh. Interesting. I guess, I don't know, I ran out of basic voice, I guess. Well, that's embarrassing. Let's see, Evernote. Standard podcast. Start for free. Oh God. No. Oh boy, that doesn't work. Chug a chug chug, spinny wheel.
The Southern District of Ohio, among other participating districts, streamed eligible civil proceedings live on the court's own YouTube channel, with recordings retained for public playback for up to a year. This institutional pattern is reinforced, rather than undercut, by what individual judges have done on their own initiative when left to choose. Sitting judges in at least 2 states currently operate voluntary, judge-initiated live streams of their own dockets, independent of any institutional.
I knew that was going to be a bad gig. But it was annoying that it was there, so. Oh, that's great. So we clipped it. Why is all this stuff so annoying? It's not even using services. Let's try a different one. Paper to audio. Of course, everything's got to try to sell you something. Which, I mean, I guess makes sense. But at the same time is very freaking annoying. No, we don't want the UK guy. Let's go with definitely free. Okay, never mind, I don't care. I still don't care.
The Southern District of Ohio, among other participating districts, streamed eligible civil proceedings live on the court's own YouTube channel, with recordings retained for public playback for up to a year. This institutional pattern is reinforced, rather than undercut, by what individual judges have done on their own initiative when left to choose. Sitting judges in at least 2 states currently operate voluntary, judge-initiated live streams of their own dockets, independent of any institutional mandate. Judge David Fleischer of the Harris County, Texas Criminal Court at Law has live streamed his misdemeanor docket on YouTube every session since the COVID-19 pandemic, adopting the practice specifically to preserve public access when in-person attendance was restricted, and continues it today. In Michigan, Judge Jeffrey Middleton of the St. Joseph County 3B District Court and Judge J. Cedric Simpson of the Washtenaw County 14A District Court each operate their own regular live-streamed dockets as well. Judge Middleton's practice briefly illustrates the privacy objection this petition anticipates in Section 15 below, and its resolution. In 2021, he temporarily suspended his livestream after a state court administrator raised privacy concerns, only for that same administrator's office to apologize for the resulting confusion and to affirmatively urge judges statewide to continue live streaming their proceedings. That episode is instructive precisely because the privacy concern was raised, considered, and resolved in favor of continued openness by the institution charged with weighing it, not because the concern was frivolous, but because it did not, on examination, outweigh the value of the practice it threatened to end. These are not proposals urged on the judiciary from outside the profession. They are individual judges, given the discretion to record their own courtrooms, consistently choosing to do so. These examples establish three things relevant to this petition. First, presumptive or routine public live streaming of trial court proceedings is an operating model already in use across multiple state court systems, not a novel proposal without precedent. Second, where these programs have been evaluated by the institutions that ran them, the recurring finding has been the absence of significant administrative or technical obstacles, precisely the concern Section V above addresses with respect to Arizona's own existing infrastructure. Third, where individual judges retain the discretion to record their own courtrooms rather than having the choice made for them by rule, they consistently choose to do so and continue doing so, which is a form of evidence an institutional mandate cannot manufacture on its own. This petition asks Arizona's courts to join a practice other states have already normalized, using capability the Arizona Judicial Branch has already built. 7. The cost objection is answered by the history of public participation data projects to the extent any opposition to this petition rests on the premise that indexing, captioning, or otherwise making a large volume of court recordings genuinely usable to the public is prohibitively expensive. That premise is contradicted by well-documented precedent for solving problems of exactly this scale and character through public participation rather than dedicated professional expenditure. Beginning in 2007, Carnegie Mellon researcher Luis von Arn's reCAPTCHA system presented ordinary Internet users, in the course of routine website security checks, with words from scanned books and newspaper archives that optical character recognition software had failed to identify. Each user's routine act of typing the word to prove they were human simultaneously supplied a data point toward digitizing the underlying text. The system digitized more than a century of the New York Times archive and, over its lifespan, enlisted several 100 million people, by some accounts more than 1 billion, in transcribing text at a volume and speed no dedicated professional transcription effort could plausibly have matched, at a fraction of the cost, without any participant needing to know they were contributing to an archival project at all. Von Arn's earlier Especially game, launched in 2003 and later licensed by Google as the Google Image Labeler, applied the identical principle to image data. Two strangers, shown the same unlabeled image and asked independently to describe it, generated reliable, human-verified labels for the image whenever their guesses matched, at a scale that produced 1.3 million labels across 300,000 images within 4 months of launch. A related game, Peekaboom, had one player reveal portions of an image while a second player guessed the word being depicted, generating training data that helped computers learn to locate objects within images. The specific example most often used to demonstrate the concept involved exactly this kind of paired guessing game built around a simple image, such as a frog. The lesson of this history is directly applicable here. The most difficult and seemingly expensive data processing problems of the early Internet era, digitizing millions of books, labeling hundreds of thousands of images, were solved not by expanding professional staff, but by converting the underlying task into a form of public engagement that people would do anyway, or would do willingly for a small, low-cost incentive. This petition does not ask this court to solve every downstream indexing or accessibility problem inherent in a large public video archive before adopting a presumption of openness. It asks the court to recognize that public engagement with court recordings, including on platforms such as YouTube, which the pending petition in R-26-0051 treats as a hazard to be minimized rather than a resource to be understood, is not the cost this court must bear alone. It is, on the documented history of comparable problems, the single most effective and least expensive tool available for solving exactly the kind of large-scale public record challenge that openness at this scale would create. This petition further submits that the most legitimate form public access can take is direct access to the official record itself, rather than to any intermediary's account of it. where a court's own video archive is directly linkable, where a citizen, a journalist, or another court can point to the specific minute of a specific proceeding as the source for a specific claim, in the same way a legal citation points to a specific page of a specific reporter. The resulting public discourse is anchored to a verifiable, primary source in a way that second-hand narrative, however well-intentioned, cannot replicate. That is the legitimacy this petition asks the court to make possible, not court proceedings translated for the public by whichever intermediary reaches them first, but court proceedings the public can verify against the primary record for themselves, at the specific place in that record where the claim being tested actually occurred. 8. The eroded function of nominal OPENNESS Rule 122's current structure was substantially shaped by a technological and economic reality that no longer exists. At the time cameras in courtrooms were first regulated, recording equipment was large, obtrusive, and operated by a small number of credentialed professionals. The population capable of exercising the theoretical right of public access was constrained mainly by whether they could physically appear at the courthouse during business hours. That constraint has not disappeared. If anything, it has become more binding, as discussed in section IX below. But the technological constraint that justified channeling coverage exclusively through professional media has been eliminated by inexpensive, high-quality, and already installed recording and streaming technology. A courtroom that is unlocked but empty is not, in any functional sense, open. The doctrine requires more than the absence of a locked door. It requires that the public's practical ability to observe be commensurate with the significance of what is being observed. Where that practical ability has collapsed, through cost, scheduling, and the disappearance of any local information infrastructure that once translated courtroom proceedings into something the broader public could access, the formal right of attendance persists while its constitutional function does not. 8a. Arizona had the opportunity to adopt a categorical ban on courtroom cameras and declined, a choice that stands in stark contrast to the state's own unaccountable surveillance default. Today, the premise underlying Rule 122's current discretionary structure, that a recording device in a courtroom presents a danger requiring case-by-case gatekeeping, is not a timeless judgment about the nature of cameras. It is the residue of a specific historical reaction to a specific historical event, adopted by a specific professional body, at a moment when the technology capable of recording a trial and the technology capable of provoking a media circus around one were, for practical purposes, the same technology. Arizona was not required to adopt that reaction, and the fact that Arizona chose a narrower path than nearly every other American jurisdiction chose at that moment is itself evidence this court should weigh. The modern prohibition on courtroom cameras traces to a single event, the 1935 trial of Bruno Hauptmann for the kidnapping and murder of Charles Lindbergh's infant son, at which newsreel cameras produced a media spectacle widely regarded as the low point of American trial coverage. In direct response, the American Bar Association amended Canon 35 of the Canons of Judicial Ethics in 1937 to prohibit photographic and broadcast coverage of court proceedings outright, and extended that prohibition to television in 1952. The reaction across the profession was near total. The entire federal judiciary and every state judiciary except Colorado and Texas adopted the ban in their own courts. That was the environment in which the question of camera coverage in Arizona's own courts first actually arose, not a neutral starting point, but a national professional consensus, followed by every state but two, that the correct response to a single catastrophic trial was categorical prohibition. Arizona did not follow that consensus when the occasion actually arose. A contemporaneous 1957 law review survey of camera practices nationwide reports that an Arizona court permitted photographic coverage of a murder trial in July 1954, squarely within the Canon 35 era, less than 20 years after Hauptmann, and while categorical prohibition remained the practice in every state but two, describing it as the first time photographs of a trial had been permitted in Arizona's history. Gilbert Gaze and Robert E. L. Talley, Cameras in the Courtroom, 47J. Crim. L. Criminology and Police Sci. 546, 548, 1956-57. That source identifies the defendant as William E. Demand, tried for the murder of a neighbor. A 2020 account of Scottsdale's early history describes the same underlying incident, the 1954 shooting of Scottsdale Town Councilman Vernon Don Jim Frederick by his neighbor, a photographer named Bill Demand, corroborating the case's basic facts, though the 1957 article's identification of the location as Scottsboro appears to be an error, no place by that name existing in Arizona. Whatever the outcome of the trial itself, on which the historical record available to the petitioner is silent, the fact that contemporaneous legal literature preserves stands on its own. At the one moment when categorical prohibition was the professional default nearly everywhere else, an Arizona court did not adopt one, and instead permitted the very kind of coverage this petition asks the court to make presumptive. That choice is further evidence that Arizona's own courts have never actually treated recording as presumptively dangerous to the proceedings it depicts. Rule 122's present discretionary, request-based architecture, which, unlike Canon 35, has never rested on the premise that a recording device is inherently and irreconcilably destructive of courtroom dignity, requiring exclusion as a category regardless of the circumstances of any particular proceeding, is best understood as continuing the choice Arizona's courts made in July 1954, not reversing it. This petition asks the court to complete that trajectory rather than retreat from it by expanding, as the task force petition would, the very category of restriction Arizona's courts declined to adopt at the one moment it was the national default. The petitioner asks this court to hold that history against the present moment, because the present moment has inverted the conditions that made restraint on cameras even superficially plausible in 1937. In 1937, a recording device was a large, obtrusive, and rare piece of professional equipment. A court that wished to control who recorded a proceeding could do so simply by controlling physical access to a small number of cameras and the credentialed operators who ran them. That constraint is gone, and this petition need not argue that it is gone. The state's own law enforcement apparatus has already conceded as much, at a scale no 1937 ABBA delegate could have imagined. As of this petition's filing, more than 2,277 automated license plate reader cameras have been publicly reported across Arizona, including 146 in Tucson alone, making Arizona the 15th most camera-surveilled state in the country by this measure. These cameras operate continuously, indiscriminately, and without individualized suspicion. They photograph the license plate, make, model, and color of every vehicle that passes, logging where Arizona residents go, when, and how often, whether or not any occupant is suspected of any offense. That data is retained, is searchable by the agencies operating the cameras, and, depending on each agency's own configuration, may be shared with other Arizona agencies or with a nationwide network reaching federal immigration enforcement, all without a warrant, an individualized finding, or any process remotely resembling the on-the-record showing this petition's proposed rule text would require before a single court hearing could be recorded. Independent analysis has documented this same infrastructure being used to monitor participants in political demonstrations, including within Arizona. The flock safety infrastructure described above is itself proof of a capability the judiciary claims not to have. It is an AI-driven system, the same automated, machine learning-assisted analysis that flags, sorts, and indexes millions of license plates without a dedicated human reviewer for each record could, applied to court recordings rather than parking lots, solve precisely the indexing and captioning problems Section 7 above addresses through the recapture and especially game precedent. The state has already built, and pays private vendors to operate, artificial intelligence capable of processing an enormous, continuous volume of visual data about ordinary residents at a scale no team of human clerks could match. That the same category of technology could instead be pointed at making the public's own courts observable, searchable, and archived is not a hypothetical extension of the petitioner's argument. It is the flock system's existing architecture, repurposed toward a public rather than a surveillance end. The task force petition moves in the opposite direction. As discussed in Section 18 below, it would expand the definition of a restricted, recording device to expressly include a device that uses artificial intelligence, subjecting the ordinary use of an AI tool in connection with a court proceeding to the same advance permission requirement, backed by contempt or criminal exposure, that currently governs a video camera. The petitioner submits that this instinct, to treat the newest and most capable class of information processing tool as the one most requiring exclusion, rather than the one most capable of solving the indexing and access problems this petition identifies, has already been rejected as poor engineering judgment by the very communities most protective of rigor and security. Linus Torvalds, the creator and chief maintainer of the Linux kernel, the software foundation underlying the large majority of the world's servers, including, in all likelihood, systems on which Arizona's own court records are hosted, confronted an analogous internal push in July 2026 to categorically exclude AI-assisted contributions from kernel development on the theory that the tool itself was suspect regardless of the work it produced. He rejected that position in direct terms. Linux is not one of those anti-AI projects, and if somebody has issues with that, they can do the open source thing and fork it. Or just walk away. AI, he said, was simply a tool, just like other tools we use. And it's clearly a useful one. The Linux kernel is maintained under review standards at least as exacting as anything at issue in an Arizona courtroom. If the community responsible for the software running the world's critical infrastructure has concluded that a contribution should be judged by its output rather than excluded by category, this court has no comparable engineering justification for reaching the opposite conclusion as to recording devices generally, or AI tools specifically. At the moment, those tools are most capable of making its own proceedings observable. The petitioner submits, further, that treating an entire and rapidly maturing category of information technology as presumptively excludable, while the state's own law enforcement apparatus deploys that same category of technology against the public without hesitation, warrant, or advance notice, cannot be reconciled with either the common law's own adaptive tradition or the natural law premise underlying the open courts doctrine itself. The common law has never treated a new means of preserving or transmitting information about public proceedings as inherently disqualifying. It absorbed the printing press, the newspaper, the photograph, and the broadcast microphone into the ordinary practice of open justice, in each instance over initial resistance from within the profession, as Section 8 above describes. A rule that excludes the current generation of that same category of tool, at the exact moment it is most capable of solving the access and indexing problems this petition identifies, does not continue that tradition, it breaks from it. And the premise that Richmond newspapers traces to a practice of ancient origin, that the public possesses an inherent claim to observe the administration of justice done in its name, prior to and independent of whatever positive rule a court adopts to manage that observation, cannot be squared with a rule structure that treats the most capable tool available for exercising that claim as the one tool requiring the state's advance permission to use. This is the world Rule 122 currently operates in, and the contrast is not rhetorical. It is the precise inversion of the appearance of justice described in Section I. The state has built, funded, and continues to expand an apparatus that surveils the ordinary movements of every resident of this state continuously and by default, without consent and typically without knowledge, for purposes the state alone controls and may change without any resident's input. The one institution that decides, on the record and under color of law, whether a specific resident goes to prison, loses a child, loses property, or loses liberty is the one institution that has arranged to be recorded only upon advance request, granted at that same institution's own discretion, subject to findings that same institution alone gets to make. A citizen's car is tracked by default. A citizen's trial is not observable by default. That asymmetry runs backward, and it runs backward in exactly the direction Section I warns against. The branch of government most in need of the appearance of just authority has made itself hardest to see, while the apparatus with the least individualized process has made surveillance of the public its ordinary, unremarked baseline. The practical mechanics of Rule 122's request process compound this. A member of the public who wishes to observe a specific hearing may walk into an open courtroom today, without notice to anyone, and watch. That much of the ancient, right Richmond newspapers describe survives intact. But that same member of the public cannot record what they are watching without having identified, in advance, the specific hearing, the specific courtroom, and the specific date, and submitted a request within whatever window the presiding court requires, a minimum of 48 business hours for a routine hearing under existing local practice, and, under the task force petitions proposal, a minimum of 5 court days. A citizen who walks past a courtroom, notices a proceeding underway, and wants to record 10 minutes of it to understand what is happening cannot do so, not because the proceeding is closed, not because any judge has made any finding that recording would cause harm, but because the citizen lacked the foresight to file paperwork for a hearing they did not yet know they would want to observe. No comparable foresight requirement attaches to the cameras cataloging that same citizen's movements to and from the courthouse parking lot outside. The financial and structural barriers to physical attendance. Physical attendance at a court proceeding is not a costless act available equally to all members of the public whom the doctrine is meant to serve. It requires transportation, parking, often a full or partial day away from paid work, and, for many of the people whose interactions with the justice system are most in need of public visibility, including self-represented litigants, low-income defendants, and individuals with disabilities, burdens that are prohibitive rather than merely inconvenient. Arizona's contemporary work week norms, unlike the agrarian and small-town patterns under which many of the doctrines and rules governing court access first developed, offer little slack for the average working adult to travel to and sit in a courtroom during business hours simply to exercise a theoretical right of observation. A rule that conditions meaningful public access on the ability to absorb these costs does not administer justice openly to the public described in Article 2, Section 11. It administers justice openly to the subset of the public that can afford to watch. Presumptive public streaming and archival removes this financial precondition entirely, at a marginal cost to the judicial branch that, per Section V above, is already substantially absorbed. Ixay. What the open courtroom actually looks like, once the high-profile case is set aside. Section 8 above observes that a courtroom unlocked but empty is not, in any functional sense, open. This section takes that observation out of the abstract. The premise this petition asks the court to confront directly is not that Arizona's courtrooms are technically closed. They are not, but that the technical right of any citizen to walk in and watch has, for the overwhelming majority of the docket, no practical exercise behind it at all. This is not a matter of inference, it is documented. A 2022 empirical study of the Cook County criminal courts, built on 3,144 minutes of direct, in-person court observation conducted over 4 months at one of the largest felony court systems in the country, found courtrooms that routinely remained locked past their listed start times while the people required to appear waited outside the doors, and a culture inside those courtrooms, once opened, that the researchers likened to a company break room among the clerks, prosecutors, and defenders who staff them day after day. Maria Hawillo, Kat Albrecht, Meredith Martin Roundtree and Thomas Geraghty, How Culture Impacts Courtrooms. An empirical study of alienation and detachment in the Cook County court system, 112J. Crim. L. and Criminology 245, 2022. Nothing about that structure was built with an outside observer in mind, because as a matter of routine practice there typically is not one. The gallery itself, when it is occupied, is not occupied by the public this petition's doctrine is concerned with. Standard descriptions of ordinary courtroom practice confirm what any regular courthouse visitor already knows. The seats behind the bar are filled primarily by defendants who are out on release and waiting for their own case to be called, and by the family members who came with him, not by independent citizens who arrived to observe the administration of justice as a civic matter. The audience for an ordinary hearing is, in other words, drawn almost entirely from the docket itself. It is not the public Richmond newspapers and this petition's sections 3 and 3A describe. It is the case's own participants waiting their turn. The existence of volunteer court watching programs is itself proof of this absence, not a rebuttal to it. Organizations that recruit and schedule volunteers specifically to sit in courtrooms and observe proceedings would have no reason to exist if ordinary public attendance already occurred on its own. Their own stated rationale for doing this work confirms the point. Court Watch organizers report that what we've seen over the past few years is that our presence really does matter. It changes people's behavior. Judges set lower bail when they know court watchers are watching. If organized, scheduled, volunteer observation changes outcomes precisely because it is otherwise absent, then its ordinary absence is not a neutral fact. It is the condition against which those outcomes are otherwise produced, unobserved by anyone but the participants themselves. Nor does press coverage fill the gap the petitioner is describing, and it is important to be precise about why. The premise that a free press stands in for the public at large in the ordinary case has been overtaken by two independent developments, each of which narrows rather than widens actual coverage. First, the specialized court beat, the reporter whose job was to sit in courtrooms and cover the docket as a matter of course, not only the exceptional case, has been, in the words of one National Wire editor, decimated as newspapers have eliminated the position under financial pressure, leaving many jurisdictions with no reporter covering routine proceedings at all. Second, and independently, the local news organizations that once employed those reporters are themselves disappearing. The most recent nationwide survey found 213 American counties are now news deserts with no local news source whatsoever, and another 1,524 counties have only one remaining outlet, together leaving roughly 50 million Americans with limited or no access to local news, a decline of nearly 3,500 newspapers since 2005. Arizona has not been exempt. Multiple Arizona newspapers that closed in recent years served as the newspapers of record in their communities, the outlets of record where legal notices and public proceedings were traditionally published, and their closure has left documented gaps in local government transparency independent of anything this petition addresses. Even where press coverage of a courtroom does survive, it survives selectively, and the selection mechanism is commercial rather than civic. As one law review analysis of high-profile trial coverage has put it, the mini-industry that lives on these notorious cases promotes a demand for coverage in order to justify its own existence. Outlets cover the case that will draw an audience, not the docket as a whole, a dynamic the newspaper editors and judges surveyed in the 1957 law review discussed in Section 8 above already identified as their industry's own guiding logic. That a notorious criminal case, or a case with a defendant already known to the public, draws cameras, reporters, and public attention proves nothing about whether the docket generally is observed. If anything, it proves the opposite, because it demonstrates that observation is the exception reserved for the case already guaranteed to sell, not the default condition of Arizona's courts. The barrier described above is not confined to the courtroom gallery. It extends to the record of the case itself, and the petitioner encountered it directly while preparing this petition. Arizona's public docket search systems display case captions, party names, and the statutory citation for each charge, but not the charging documents, the factual basis for any count, or the substance of the motions listed on the docket. A member of the public who wants to know not merely that a case exists but what it actually alleges must either pay per-page copying fees to the clerk's office for each document requested, or appear in person at the courthouse during business hours to review the file directly. While researching this petition, the petitioner reviewed a public docket in a pending Pima County Superior Court criminal matter showing 13 separate counts charged under 2 subsections of a single harassment statute that, by its own terms, defines the offense as a series of acts rather than a discrete, individually punishable act, the kind of charging pattern that ordinarily warrants scrutiny under Arizona's unit of prosecution doctrine. See State version. Jordan, 239 Arizona. 526, 528-29, 2016, State version. Hoffman, 78 Arizona. 319, 328, 1955. Multiple counts for a single statutorily defined offense violate double jeopardy where the offense is defined by the conduct, not the number of instances. Confirming whether that scrutiny is warranted requires reading the actual charging document to see whether each count alleges factually distinct conduct or repackages the same continuing course of conduct 13 times over, and that document was not obtainable without clearing one of the same 2 preconditions, payment or physical presence, that Section IX above identifies as the ordinary barrier to observing a hearing in the first place. If the underlying conduct amounts to a single continuing offense charged as 13 separate counts, that fact is presently invisible to anyone who cannot clear one of those 2 preconditions, which, on Section IX's own analysis, describes most of the public most of the time. The record is gated behind the same wall as the gallery. This is the distinction the petitioner asks the court to hold onto through the remainder of this petition. The integrity section I describes is not the integrity of a court that performs well when everyone happens to be watching a particular case. Any institution can hold up under that kind of attention, and the fact that it does proves little, because scrutiny in that instance is being supplied by people paid to provide it, drawn to that one case by its market value rather than by any systemic commitment to observing the ordinary business of the court. The integrity this petition is actually concerned with is whether the court functions the same way in the thousands of cases that draw no reporter, no volunteer, and no member of the public at all, the arraignment calendar, the routine plea, the discovery dispute, the motion practice described in Section 11 below, because that undifferentiated mass of unobserved proceedings, not the handful of cases that happen to become newsworthy, is where the overwhelming majority of Arizona residents actually meet the justice system. A rule structure that leaves that majority permanently unobserved, while treating the rare televised case as proof that the system is open, has mistaken the exception for the rule. X. The judicial branch is the one branch of government the public is structurally excluded from. The financial barriers described in section IX above operate alongside a separate and more fundamental exclusion, and this petition submits that the two compound one another. A member of the public may vote for, write to, testify before, and directly petition the legislative branch without any license or credential. A member of the public may apply for permits, request records, attend public meetings, and otherwise interface directly with the executive branch and its agencies without any license or credential. The judicial branch alone requires a license to participate in its central function. Arizona Supreme Court Rule 31 makes the practice of law, representing another's interests before a court, and in many contexts effectively representing one's own with any competence, unlawful without bar admission, while no equivalent restriction prevents any person, licensed or not, from teaching, writing about, or publicly explaining the law. The state restricts practicing law but not explaining it, which means the public is free to consume commentary about the judicial branch but is not free to participate in its operation on equal footing with a credentialed class. This asymmetry would matter less if the judicial branch's actual operations were nonetheless visible to the excluded public, in the way that legislative floor votes and executive agency actions are visible even to those without standing to directly participate in them. Rule 122's current structure ensures they are not. The result is a branch of government that the public cannot participate in without a license, and cannot routinely observe without extraordinary effort, layered on top of one another. A citizen who is not a lawyer has no direct interface with how the law is actually applied, which is the function of the judicial branch, as distinct from the legislative branch that writes the law and the executive branch that enforces it, and, under the current rule, very often no meaningful way to observe that application either. The petitioner submits that a judicial branch structured this way should expect exactly the erosion of public confidence and the disconnection from popular oversight documented throughout this petition, because it has arranged, through two independent and mutually reinforcing barriers, to be the branch of government least accountable to direct public scrutiny. This structural exclusion is compounded by what the public receives in place of direct observation. Absent presumptive access to the underlying record, what reaches most of the public is neither the raw proceeding nor the raw document, but a curated narrative, a news clip, a summary, a characterization filtered through whatever institutional or commercial incentives shaped its selection and framing. Journalistic coverage of ordinary court proceedings, as distinct from the small number of cases that become sufficiently notorious to attract sustained scrutiny, is neither comprehensive nor, in the petitioner's submission, reliably accurate as to the underlying record. It is also structurally more likely to reproduce an official account than to challenge one, since the official account is the more accessible and more readily quotable source. A public that can access only curated narrative about its judicial branch, rather than the branch's own primary record, is not in a meaningfully different position than a public excluded from that branch altogether. It has simply substituted one filter for another, neither of which it can independently verify against the underlying proceeding. There is, in addition, a basic economic irrationality embedded in expecting the public to master the law despite this exclusion, and this petition asks the court to account for it directly. Law is among the most extensive and internally complex bodies of material a person can study. No single individual, lawyer or otherwise, comes close to mastering the whole of it, which is precisely why the profession itself has fragmented into specialties. A rational person allocates the effort required to learn something difficult in proportion to the use that person will be permitted to make of it. Where the state forecloses any productive use of legal knowledge beyond the passive duty to obey, since Rule 31 prevents a non-lawyer from applying that knowledge on another's behalf, and frequently, as a practical matter, from applying it competently on his own behalf in any proceeding of consequence, the state has removed the ordinary economic incentive that would otherwise justify the average person's investment in learning it. Expecting broad public legal literacy under these conditions is not a neutral aspiration. It asks the public to master a discipline the state has simultaneously told it not to bother mastering, since mastery confers no license to use it. If this court intends to maintain the restriction on unauthorized practice in anything like its current form, the petitioner submits that the state bears a corresponding obligation to do everything within its power to make the operation of the law observable to the public it has excluded from practicing it. because observability, not participatory mastery, is the only form of engagement with the judicial branch the state has left available to the ordinary citizen, and Rule 122 currently forecloses even that. This deficit does not remain confined to the judicial branch. It propagates into the other two branches the public actually votes for, and this petition asks the court to recognize that consequence as well. The restriction that produces it is not an act of the legislature. It is the Arizona Supreme Court's own rule, grounded in this court's constitutional and inherent authority over the practice of law under Article 6, Section 1 of the Arizona Constitution, rather than in any statute enacted through the ordinary legislative process. A citizen votes for legislators on the understanding that those legislators write the law, and for executive officials on the understanding that those officials faithfully execute it. Both of those judgments presuppose that the voter has some capacity to evaluate the law's quality and its faithful execution, and the preceding paragraphs of this section establish why that capacity does not meaningfully exist for most of the electorate, for reasons flowing directly from a restriction this court itself imposes and could, within its own authority, choose to counterbalance. A public that cannot assess the law it is asked to vote on cannot meaningfully hold the legislative branch accountable for the law's quality, and a public that cannot assess how the law is applied cannot meaningfully hold the executive branch accountable for its execution. The petitioner submits that a restriction adopted by this court, under authority this court alone claims to possess, should not be permitted to degrade the electorate's capacity to hold the other two branches of a Republican government accountable, without this court doing everything within its power to supply the one substitute capacity still available to it: the ability to see, directly and without a lawyer's mediation, how the law it has restricted the public from practicing is actually applied. This is not how the founding generation understood the relationship between ordinary citizens and law. Of the 39 signers of the United States Constitution, 22 had legal training, leaving 17, well over 2/5 of the group, who did not. Benjamin Franklin, among the most consequential of them, was a printer, scientist, and diplomat, not a lawyer, and was understood by his contemporaries to be fully capable of engaging with constitutional design on that basis. The Federalist Papers were themselves an enormous, sustained investment of effort, 85 essays, written under deadline, published serially in the popular press, undertaken for the specific purpose of making the reasoning behind the proposed Constitution comprehensible to the ordinary voters of New York whose ratification votes would decide its fate. That project presupposed that ordinary citizens, without legal training, were capable of evaluating constitutional structure for themselves, provided the material was made accessible to them. The financial and human effort the framers were willing to expend on that project of public legal education, using the technology of their era, dwarfs what this petition asks of the Arizona judicial branch, using infrastructure it has already built and is already using for other purposes. Whatever gap existed between professional legal training and ordinary public competence in 1787 has only widened since, and this petition submits that the advent of artificial intelligence is accelerating that widening in a way this court should not ignore. Building or constraining an AI system to operate reliably within a legal framework does not merely require legal knowledge. It requires the simultaneous application of distributed systems engineering, advanced probability and statistics, natural language processing, and the classical data extraction techniques, optical character recognition and its successors, that convert raw documents into material a model can reason over, layered on top of the legal substance itself. No individual, lawyer or engineer, masters that combination alone. The work is necessarily distributed across specialists who must each understand enough of the other's domains to interface with them. A profession and a rule-making structure built around the premise that legal competence is a single, unified credential a person either holds or lacks is increasingly out of step with a world in which competent engagement with the law is already, of necessity, distributed across people who hold no bar license at all. The petitioner submits that a judicial branch entering this century while insisting on a licensing monopoly modeled on 19th century assumptions about how legal knowledge is produced and applied will serve the public even less well than it does today, unless it commits, starting with the openness this petition requests, to making its own operations the one thing every specialist, licensed or not, can still observe directly. 11. A documented pattern, ELASTIC public order and sentencing mechanisms operating without visible scrutiny consistent with Section I above. The examples in this section are offered solely to demonstrate the absence of contemporaneous public visibility into the ordinary operation of Arizona's courts, not to establish the truth of any disputed allegation or the correctness of any outcome. In each instance, the petitioner asks only that the court observe what was, and was not, capable of being seen by the public while the proceeding was underway. The question of appearance this petition is concerned with, wholly apart from any question of adjudicate fact. In the petitioner's own pending matter, State of Arizona version. Jensen, Tucson City Court Number C26,007,889, body-worn camera footage, obtained only after months of contested discovery and multiple motions to compel, contains statements attributed to the arresting officer describing the purpose of the arrest in the officer's own recorded words. I think it's going to be enough to scare him away, and later, I think he's getting the hint. The charge deployed, disorderly conduct under ARS Section 13-2904, turns substantially on the subjective characterization of an uncross-examined witness. A 911 call recording in that matter reflects a statement, attributed to the complaining party, that a Tucson police officer had contacted her in advance regarding the possibility of a disorderly conduct charge, a contact not referenced in the initial police narrative provided in discovery. The petitioner does not ask this court to find that this sequence establishes misconduct. He asks the court to note that none of it was visible to the public, or knowable by anyone outside the litigation, until the petitioner himself extracted it through discovery motions spanning several months. The same matter illustrates a second, related structural problem. The state's discovery practice compressed meaningful review into the days immediately preceding hearings, and the state's charging theory changed after the petitioner's motion practice addressed the theory as originally charged. On February 12, 2026, following the petitioner's motion to dismiss addressing the specific conduct charged under ARS Section 13-2904, 3, a subsection judicially limited to fighting words, under in re Louis C. 197 Arizona. 84, App. 1999, the state moved to remove the specific subsection from the charging document, proposing instead to proceed on an undifferentiated, unitary offense theory encompassing all 6 subsections of ARS Section 13-2904, Whatever the ultimate merit of that motion practice, a question properly resolved by the presiding court, not this petition, none of it occurred with any contemporaneous public visibility. It is recoverable now only because the petitioner preserved and compiled his own case file. The petitioner's position is that the Tucson City Court's own practices, observed directly and currently, are themselves the clearest illustration of why this petition is necessary, and the petitioner states that position plainly. The current practice is corrupt, precisely because it is conducted where no one can see it. The petitioner's arraignment in this matter was conducted as one of a series of unrelated defendants' pleas taken in immediate succession, without individualized statement of the specific charge or case number for each defendant on the record before the defendant's plea was entered, a practice that, if routinely observed by the public, would invite immediate scrutiny under Rule 14.2, Arizona. R. Crim. P. which requires that a defendant be formally advised of the charges against him at arraignment. It survives only because no functioning mechanism exists for the public to observe it as a matter of course. The petitioner is, as of the filing of this petition, in active, ongoing correspondence with the Tucson City Court attempting to obtain audio recordings of hearings in his own matter, and that correspondence itself demonstrates the problem. For certain hearing dates, the court provided the audio recording of the entire day's calendar, encompassing matters unrelated to the petitioner's own case. For the arraignment specifically, the court provided only the isolated segment in which the petitioner appeared before the judge, with no explanation offered for the differing scope applied to different hearings in the identical case. The petitioner further paid a fee for what the court's own process describes as a transcript and received, instead, an unindexed audio file, not a transcribed written record of the kind the term ordinarily denotes. No rule articulated to the petitioner accounts for why one hearing yields a full-day recording, another yields an isolated excerpt, and a paid transcript request yields raw audio rather than a transcription. The petitioner submits that this is not a technical inconsistency, it is what an access regime that answers to no one looks like from the inside, and it is offered as a live, current example, not a historical one, of the appearance of justice harm this petition addresses. A pattern bearing directly on this inference is presented by state version. Myers, Pima County. Myers, a YouTube creator, was charged with disorderly conduct arising from public commentary critical of the Tucson City Prosecutor's Office. That charge was dismissed. Myers subsequently went public with the dismissal and continued to criticize the prosecutor's office as corrupt. More serious charges, including stalking and harassment, followed, arising from Myers' contact with individuals connected to a city prosecutor, including the prosecutor's spouse. The petitioner takes the position that this sequence, dismissal, public criticism of the prosecuting office, followed by an escalated prosecution touching the prosecutor's own family, supports the reasonable inference of retaliatory motive, and offers it for that purpose. The petitioner further takes the position that the underlying conduct attributed to Myers, on the record as publicly reported, falls within a category of activity the Supreme Court of the United States has long recognized as protected. In Martin version, City of Struthers, 319 U.S. 141, 1943, the court held that door-to-door canvassing and the distribution of literature to residents, activity the court described as a practice of ancient origin through which private citizens communicate ideas or invitations to their neighbors, is protected First Amendment activity that a municipality cannot broadly prohibit, a holding the court reaffirmed in Watchtower Bible and Tract Society version. To the extent the conduct attributed to the petitioner notes that Frisbee version, Schultz, 487 U.S. 474, 1988, permits a narrower category of restriction, focused picketing directed at a single residence, repeated to the point of functioning as a targeted siege of one household, but that narrow holding does not convert general canvassing, door-to-door contact, or the distribution of information to residents of a neighborhood into unprotected conduct. To the extent the conduct attributed to Myers consisted of the latter rather than the former, the petitioner takes the position that characterizing it as criminal stalking or harassment does not fit the distinction the court's own precedent draws, and that the absence of any contemporaneous public record of what actually occurred is what has allowed that characterization to go untested. This position is reinforced by the text of the statute itself. ARS Section 132921, A2, and A4, the following and surveillance prongs of Arizona's harassment statute, require that the conduct at issue serve no legitimate purpose before it can be criminalized. This is not an incidental phrase but an element the state bears the burden of proving. Subsection E further requires that the conduct be of a kind that would cause a reasonable person to be seriously alarmed, an objective standard, not a subjective one dependent solely on the complainant's stated fear. Investigating a sitting prosecutor's alleged misconduct, including contacting individuals connected to that prosecutor in the course of that investigation, is the ordinary and legitimate work of journalism, however conducted and by whomever conducted. A charging decision that treats such investigation as satisfying the no legitimate purpose element, rather than as the paradigm case of a legitimate purpose, does not apply the statute as written. It substitutes the discomfort of the official under investigation for the objective standard the legislature enacted. The petitioner takes the position that this is precisely what occurred, and that the same absence of contemporaneous public visibility discussed throughout this petition is what permits such a charging decision to proceed unexamined by anyone beyond the parties to the case. The petitioner further takes the position that the underlying charges cannot be evaluated in isolation from what investigative journalism has always required. Contacting a subject's spouse, family, neighbors, and associates is not a deviation from newsgathering. It is newsgathering, as practiced by every investigative reporter who has ever worked a story involving a public official. A rule of practice under which such contact is celebrated as diligence when performed by credentialed press, but charged as stalking or harassment when performed by an independent YouTube creator investigating the same public official, does not identify a difference in conduct. It identifies a difference in who is doing the investigating, and specifically whether that investigator carries institutional backing sufficient to resist the charge. The petitioner submits that this is precisely the dynamic Section 12, below, addresses. The absence of institutional backing is what determines whether investigative conduct is treated as protected scrutiny or prosecuted as a crime, and that absence falls disproportionately on independent citizen journalists rather than on any difference in what was actually done. The petitioner's own matter presents a parallel record of shifting, mutually inconsistent charging theories advanced by a succession of 3 different assigned prosecutors over the course of the litigation. A sequence the petitioner submits is itself probative of the absence of any fixed, good faith theory of the case, rather than a coincidence of routine reassignment. The state has, at various points, taken the position that the petitioner's presence on a public sidewalk was independently, seriously disruptive, under ARS Section 13-2904, A.1, that his voice constituted unreasonable noise under subsection A.2, notwithstanding that the responding officers were stationed across the street and did not independently perceive the volume the charge alleges, and that a hand gesture, made while the petitioner was being photographed at a distance by the complaining party, constituted conduct likely to provoke immediate physical retaliation under subsection A.3, a theory that, applied even-handedly, would equally criminalize the act of photographing a stranger without consent, since the record reflects that being photographed by an unfamiliar party, not the photography itself, was the actual source of friction in the underlying encounter. The state additionally moved to prosecute this matter under a unitary offense theory encompassing all 6 subsections of ARS Section 13-2904, A, including subsection A.6, a felony provision the city court, a limited jurisdiction tribunal, lacks authority to adjudicate. At the federal level, this same structural pattern, coercive or elastic mechanisms whose validity was never subject to meaningful contemporaneous review, was recently addressed by the United States Supreme Court in Hunter version. United States 606 US___2026. There, a defendant convicted of a non-violent financial offense, with no judicial finding of dangerousness to himself or others, was made subject to a sentencing condition requiring him to take all mental health medications prescribed by his treating physician, over his objection. The Fifth Circuit initially held his claim barred by an appeal waiver executed as part of his plea agreement. The Supreme Court reversed, 8-1, holding that enforcing the waiver against a potentially unconstitutional sentencing condition would constitute a miscarriage of justice. Justice Gorsuch, concurring, described the practice from which this case arose in terms directly relevant to this petition. In our times, the jury trial has given way to a conveyor belt of plea bargains, and this court has often condoned those practices or let them pass in silence. Each of these matters shares a common structure, regardless of how each is ultimately resolved. A mechanism operating with minimal contemporaneous visibility, surfaced to any scrutiny at all only through extraordinary, individually born effort. That structure is what damages the appearance of just authority described in Section I, independent of whether the underlying conduct in any one case turns out, upon full adjudication, to have been proper or improper. An institution whose ordinary operations can be observed only through such extraordinary effort has, as to those operations, forfeited the appearance offered requires, whatever the eventual outcome of any particular case. Justice Gorsuch's diagnosis in Hunter is the same diagnosis this petition advances in Section I, and it is worth stating the connection directly rather than leaving it implicit. Hamilton's account of a judiciary possessing neither force nor will, but merely judgment, means that a court system retains its authority only for as long as the public believes its judgments are honestly reached, and a system that resolves the overwhelming majority of its cases through what Justice Gorsuch called a conveyor belt of plea bargains, largely outside any contemporaneous public view, cannot expect that belief to survive the cases where the conveyor belt's workings become visible only after the fact, as they did for Mr. Hunter and as they have for the petitioner in the matters described above. This is not a uniquely federal insight. Arizona's own courts reached the identical conclusion in a different posture, holding that the removal of a sitting justice of the peace for willful misconduct was necessary to give citizens confidence in the integrity of the judicial system, in Re Lerona, 178 Arizona. 562, 875 P2D 795, 1994, not principally to redress the injury done to any single litigant before that judge, but to protect the institutional confidence on which every judgment the court would ever issue afterward necessarily depends. Hunter and Lerona arise from opposite ends of the judicial system, one from the plea bargaining machinery of the federal courts, the other from the discipline of a single Arizona magistrate, but they rest on the same premise this petition asks the court to act on. An institution whose power is merely judgment has no reserve of force to fall back on once that confidence is spent, and a rule structure that keeps the public from observing how judgment is reached in the ordinary cases spending it continuously, not merely in the exceptional one. 11a. The ethical record underlying R-25-0031 itself illustrates the problem. This petition describes a 25-0031. The petition this petition responds to does not rest its case for broadening judicial control over recording on a body of empirical evidence. It rests on a single footnoted citation, a YouTube video titled Lane Myers WINS2 Cases in 1 Day, offered as the petition's example of Rule 122H, being misused, if not openly weaponized. The petitioner has reviewed the public record underlying that same litigant's subsequent criminal proceedings and submits that R-25-31's own founding example does not withstand the scrutiny its proponents are asking this court to foreclose. Both statutes most heavily charged in the litigant's underlying cases, harassment and stalking, are by their own terms aggregate offences. Each requires a series of acts or a course of conduct, and neither can be completed by a single incident. See ARS Section 132921, A person commits harassment only by knowingly and repeatedly committing an act or acts that harass. ARS Section 132923, stalking requires a course of conduct. Yet the public docket across the litigant's two related prosecutions reflects 20 separate counts in total, 14 of them brought under those same two aggregate conduct statutes, with the remainder charged under related provisions the petitioner has not undertaken to separately analyze here. The matters were ultimately resolved by plea, to stalking in one case and to harassment, both felonies, in the other. The petitioner does not represent this count, standing alone, as proof that the charges were legally improper. The point is narrower and, for purposes of this petition, more telling. The public docket is the only information about this charging pattern that exists to be checked without cost or a trip to the courthouse, and the docket alone is enough to raise the question without being enough to answer it. That gap between what is visible and what would be required to resolve what is visible is not a defect in the petitioner's analysis. It is the condition section IXA above describes, encountered here in a specific case rather than in the abstract. The petitioner submits that this appearance is not incidental to the question before this court, whatever its ultimate resolution would show. Sections IA and 11 above describe, through Justice Gorsuch's concurrence in Hunter and Arizona's own unit of prosecution doctrine, the mechanism a docket like this one would present if the appearance proved accurate. Charge volume calibrated not to reflect factually distinct criminal conduct but to increase the cost, complexity, and risk of proceeding to trial on a statute the legislature itself defined as a single continuing offense. See State version. Jordan, 239 Arizona. 526, 2016, State version. Hoffman, 78 Arizona. 319, 328, 1955. A plea entered under that kind of pressure is not the same thing as a fact-tested adjudication. R-25-0031 nonetheless treats the outcome of these proceedings as self-evidently legitimate, citing the litigant's public commentary on him as the harm this court should act to prevent, without ever acknowledging that the same public record underlying that commentary raises the appearance question this petition raises now. The sequence that followed compounds the concern. After this litigant exercised precisely the transparency rule 122H presently allows, publicly discussing both of his own cases and, subsequently, R-25-0031 itself, he has since faced additional probation revocation proceedings within the same court system, brought in connection with the same office whose charging practices his commentary examined. The petitioner does not ask this court to adjudicate the propriety of those separate proceedings, which are not before it and which the petitioner has not independently verified beyond the public docket described in this petition. The petitioner does submit that a rule-making record which cites a litigant's public criticism of a prosecutor's office as its founding example of harm, where that same litigant is simultaneously facing renewed proceedings connected to that same office, is not a record on which this court should rely to expand the discretion of the officials whose own charging conduct prompted the criticism in the first place. This is what Section IA above means concretely, not abstractly, when it describes peace sustained without tranquility as a suppressed conflict rather than a stable achievement of law. R-25-0031 asks this court to resolve that conflict by restricting the one tool that let the public see it, rather than by examining whether the charging practices generating the litigant's commentary, and now apparently his renewed proceedings, were themselves consistent with the appearance of justice Section I of this petition describes. This court should decline to build a statewide rule restricting public observation of Arizona's courts on a foundation the petitioner submits does not bear the weight R-25-0051 places on it. 12. The false choice of self-help transparency. It might be suggested that a litigant dissatisfied with the invisibility of routine motion practice, a motion to amend a charge, a discovery dispute, a hearing at which a charging theory shifts, is free to create his own visibility by recording and publishing the proceeding or its underlying record himself. This is not a genuine alternative to institutional openness, and this petition asks the court to recognize why. A litigant who publishes his own case record, including footage, filings, or commentary drawn from a proceeding, becomes personally and individually responsible under existing law for whatever reactions that publication provokes from members of the public, in a manner an institution's own default archival function is not. Where an individual's publication of his own case draws public attention, and where members of the public who view that material then act, comment, or communicate with any party to the case, the individual who published it may himself face allegations of witness tampering, harassment, or interference founded on the independent conduct of third parties he does not control and never directed. This is not a hypothetical. It is the structural mechanism underlying the pattern discussed in Section 11, in which subjective, elastic public order and interference statutes are applied to individuals whose central conduct was recording, publicizing, or protesting matters of legitimate public concern. Presumptive institutional recording and archival eliminates this asymmetry. A record maintained by the court itself, as a routine institutional function equally available to every member of the public, does not expose the individual litigant to liability for how that record is subsequently used or reacted to by others. The current regime does not merely fail to provide transparency by default, it structures the sole practical alternative, self-help publication, so that the individual who exercises it assumes legal risk that an institutional default would not create. A rule that leaves litigants to choose between invisibility and personal legal exposure is not neutral as to whether transparency will occur. It actively disfavors it. This asymmetry is compounded by a further one. Whether investigative conduct is treated as protected newsgathering or prosecuted as criminal harassment turns, in practice, on whether the person engaged in it carries institutional backing sufficient to resist the charge. A credentialed reporter for an established outlet who contacts a public official's family, neighbors, or associates in the course of a story is understood to be engaged in ordinary investigative journalism. An independent citizen journalist who does the identical thing, without an employer's legal department behind him, faces materially greater exposure to exactly the elastic public order and harassment statutes discussed in Section 11 above. The difference is not in the conduct, it is in who is positioned to survive being charged for it. A rule structure that leaves the ordinary operations of the courts substantially unrecorded compounds this asymmetry, because it ensures that the institutional actors best equipped to contest such charges are also the ones least burdened by the current default of invisibility, while independent investigators and self-represented litigants are left to prove their own good faith after the fact, case by case, with no contemporaneous record to draw on. 13. The institutional response to this pattern has been to propose further concealment, not transparency. This pattern arises at a moment of documented, historically low public confidence in the judicial branch at every level. Confidence in the federal judiciary fell 24 points between 2020 and 2024, reaching a historic low. National surveys as of 2025 found a majority of respondents reporting little or no trust that the United States Supreme Court operates in the public's interest, a 27-point decline from 2019. This decline is not confined to a single high-visibility court. It reflects a broader collapse in the public's default posture of deference toward institutions generally, driven by the same expansion of independent information access that has reduced unquestioned deference toward every other public institution over the same period. State and local courts, though currently better trusted on some measures than the U.S. Supreme Court, operate on a comparably reduced baseline relative to a decade ago, and that comparative trust is itself untested by any meaningful public visibility into how the least visible courts, municipal and limited jurisdiction courts handling the highest volume of direct public contact with the justice system, actually conduct their business. At precisely this juncture, the pending petition in R-25-0051, filed by the Tucson City Attorney's Office and supported in comment by the Arizona Prosecuting Attorneys Advisory Council, asks this court to broaden the discretionary power of courts to restrict recording and broadcasting of proceedings. An institution confronting a documented, contemporaneous pattern of coercive and subjectively elastic mechanisms operating without meaningful visibility does not restore public confidence by making itself harder to observe. This petition submits that the correct institutional response to that pattern is the opposite of what R-25-0051 proposes. 14. The ethical dimension of R-25-0031 ITSELF. The petitioner takes the position, and states it directly, that the timing and substance of R-25-0031 raise an ethical concern this court should not decline to examine merely because the petition arrived through ordinary channels. Recording of the underlying proceedings that gave rise to R-25-0031 did not produce any injury this petitioner is aware of beyond the ordinary, uncomfortable consequence any public official faces when a matter he would prefer remain unexamined becomes visible to the public he serves. What the record reflects is not danger. It is that the institutional actors involved lost the ability to control the narrative surrounding their own conduct once that conduct was recorded. Responding to that loss of narrative control by petitioning this court to broaden the power to prevent recording in the first instance is not a neutral proposal about courtroom administration. It is an institutional actor asking the rulemaking body that oversees it to shield it from exactly the kind of scrutiny that caused it discomfort, and the petitioner submits that a request of that character, arising in that posture, is itself the appearance of impropriety. Problem section I of this petition describes, regardless of how the petition is framed on its face. The petitioner further takes the position that this court and the state bar's disciplinary apparatus cannot be relied upon to meaningfully check this dynamic once a broadened restriction is in place, because that apparatus does not meaningfully check prosecutorial conduct now. A 2013 review of every Arizona Supreme Court capital case opinion since 2002 found that prosecutorial misconduct was alleged on appeal in 42 of 82 cases statewide, and that appellate courts found actual improprieties or outright misconduct in 18 of those instances. Yet only 2 of the underlying death sentences were reversed on that basis, and only 2 prosecutors, out of that entire 18-case record, were disciplined by any oversight authority. The first prosecutor ever disbarred in this country for misconduct in a capital case was a Pima County prosecutor, the same county in which this petition and the petitioner's own prosecution both arise, and the disbarment took 7 years from the misconduct's discovery to its resolution. A Maricopa County attorney has been quoted stating plainly that he does not consider it his duty to police his own prosecutor's conduct in court, leaving that function, in his account, to defense attorneys and judges alone. This is the accountability structure into which R-25-0031 asks this court to place greater, not lesser, discretion to prevent the public from independently observing what prosecutors and courts do. The petitioner submits that an ethics complaint process with this documented a history of non-enforcement cannot substitute for the public visibility this petition asks the court to restore, and that citing the availability of that process as a reason to deny this petition would be to rely on a safeguard the record shows does not function. 15. The victim's Bill of Rights cannot be used to seek influence while avoiding scrutiny. This petition anticipates that the most frequently invoked justification for restricting public recording will be the protection of victims under Article 2, Section 2.1 of the Arizona Constitution, the Victim's Bill of Rights, or VBR. The petitioner takes the position that this justification, as typically deployed, does not withstand scrutiny on its own terms, and offers the following distinction. The VBR grants a victim the right to refuse an interview, to decline to be a witness in defense discovery, and to keep certain categories of information confidential, rights this petition's proposed amendment leaves entirely undisturbed, and which the enumerated exceptions in Section 19 below are drafted to accommodate. Nothing in this petition requires a victim who wishes to remain outside the public proceeding to be drawn into it. But the VBR also grants victims the right to be present at proceedings and the right to be heard, including through victim impact statements offered directly to the court for the specific purpose of influencing its decision. A victim who exercises that second category of right is not withholding participation. The victim is affirmatively seeking to shape the outcome of a public governmental proceeding, in a public courtroom, on the record, addressed to a judicial officer acting in an official capacity. The petitioner submits that a victim, or the state on a victim's behalf, cannot simultaneously seek that kind of influence over a public proceeding and demand that the proceeding be shielded from the public scrutiny every other participant in it is subject to. Influence over the exercise of state power and insulation from scrutiny of that exercise are not two rights that can be claimed together. The second exists specifically to check the first, in every other context in which a private party seeks to influence a public decision. A victim impact statement delivered to influence a sentencing decision is, in that moment, an act of public advocacy directed at the court, and it is difficult to identify a principled reason why that particular category of public advocacy should be the one exempted from the openness this petition asks the court to restore, when the advocacy of every other participant, the prosecutor, the defense, the court itself, remains subject to it. The petitioner takes the position that this is not what the Victims' Bill of Rights was adopted to accomplish, and that invoking it to justify blanket restriction on recording, rather than the narrow, case-specific findings this petition's proposed rule text already accommodates, extends the VBR well past the protective purpose it was designed to serve. 16. Anticipated opposition, State v. Myers. As a counterpoint, opponents of this petition are likely to point to state version. Myers as a cautionary example, on the theory that recording capability in the hands of an individual can be misused to threaten the safety or privacy of a protected party. The petitioner has stated his position on that matter directly in section 11 above. The sequence of dismissal, public criticism of the prosecuting office, and subsequent escalation to charges touching the prosecutor's own family supports the inference of retaliatory motive, not the inference that recording itself is the danger requiring restriction. Even accepting, for the sake of argument, the opposing characterization of that case, the petitioner's position does not change. Whatever occurred in Myers was addressed, and was capable of being addressed, through mechanisms Arizona courts already possess: protective orders, probation conditions, and contempt authority, entirely independent of Rule 122. Nothing in this petition would disturb a court's authority to enforce those mechanisms against an individual litigant's misconduct, however that misconduct is ultimately characterized. What this petition addresses is a distinct and separate question: whether the judicial branch's own institutional recording and public archival of its proceedings should be presumptively available to the public. Citing a single contested prosecution as justification for restricting the institution's own recording function inverts the appropriate inquiry. The petitioner submits that the more probative reading of Myers, on the record as it currently stands, is not that recording is dangerous, but that the absence of a public, contemporaneous record of the underlying dispute between Myers and the prosecutor's office is precisely what leaves this court and the public unable to determine, with any confidence, which characterization of that case is correct. A problem this petition's proposed amendment is designed to prevent from recurring, not one it would create. The petitioner offers a direct observation on this point, in keeping with the appearance standard set out in Section I. The petitioner does not purport to prove any party's intent, only to illustrate what this sequence appears to show to any reasonably skeptical observer. In Myers' own case, the state and the court articulated conditions framed in rehabilitative terms, structuring his probation, by the petitioner's understanding of proceedings in that matter, around reducing his online engagement and communication with the public in the interest of giving him an opportunity to succeed and reintegrate. At the same time, a public filing before this court, R-26-0051, part of the broader Arizona prosecutorial and judicial apparatus that includes the office prosecuting Myers, specifically discussed Myers' case, placing it back before the public. The petitioner personally observed Myers discuss that filing on a public livestream shortly afterward, a discussion that would have had no occasion to occur had the petition not referenced his case in the first place. Myers now faces a violation hearing arising from conduct in that same period. This petition does not ask the court to find that any office coordinated this sequence, or that any individual intended it. What it asks the court to see is the contradiction sitting on the face of the record. The same system that says, in one forum, that it wants to reduce Myers' public engagement with his own case for his own benefit, filed a public document in another forum that put his case back in front of the public and generated the very engagement it says it is trying to prevent, and then treated his response to that engagement as evidence against him. This petition submits that this is precisely the kind of appearance Offut warns against, and that it is exactly the sort of contradiction that only survives because the underlying proceedings are not visible enough for the public to notice it happening in real time, rather than reconstruct it afterward, as the petitioner has had to do here. 17. Relationship to pending petition R-25-0031 and the task force's superseding petition. This petition is filed against a rulemaking record that has moved since R-25-0031 was first filed. On January 7, 2026, the Task Force on Rules of the Supreme Court of Arizona, established by Administrative Order No. 2025-89, filed R-26-0003, petition to amend Rules 122 and 122.1, Rules of the Supreme Court of Arizona, the Task Force Petition. The Task Force Petition itself asks this court to review but then dismiss R-25-0031 and to consider R-26-0003 in its place at the court's August 2026 rules agenda. The petitioner accordingly directs this petition at R-26-0003 as the operative document the court will actually consider, while continuing to address R-25-0031 to the extent its content remains relevant to the petition it is slated to supersede. The petitioner requests that this petition be considered by the task force and this court concurrently with the task force petition, on the basis that both proposals address the same rules from opposing premises. Adoption of the presumption proposed in this petition would resolve, rather than merely oppose, the question the task force petition raises. A rule that presumes openness and requires specific, on-the-record justification for any restriction has no need of the expanded approval requirements, broadened definitions, and new sanctions the task force petition proposes, because the burden and the presumption have already been placed where the petitioner submits the Constitution requires them. The petitioner requests expedited consideration of this petition on the following basis. The comment period on R-25-0031 closed well before the petitioner became aware that the petition existed. The petitioner's awareness of R-25-0031 arose only recently, through Meyer's public discussion of it, as described in Section 16 above. The petitioner accordingly had no opportunity to comment within the original window afforded other interested parties, including the Arizona Prosecuting Attorneys Advisory Council and the other commenters of record in that matter, and has likewise had no opportunity to comment within any window that may separately apply to the task force petition. Because both matters remain pending and unresolved ahead of the August 2026 rules agenda, expedited consideration of this petition remains capable of placing the petitioner's position before the task force and this court before either matter is finally resolved, and the petitioner respectfully requests that opportunity. The petitioner further requests that, in light of the matters detailed in Section 14 above, this court exercise whatever inherent authority it possesses over the integrity of its own rulemaking processes to decline to adopt R-25-0031 and the task force petition, or to dismiss them outright. The petitioner draws the analogy, though acknowledges it is not directly on point, to the principle discussed in the concurring opinions in Hunter version. United States 606 US___2026, recognizing that a court's inherent authority over the proceedings before it exists to prevent outcomes that would bring the integrity of the judicial system into question, independent of whether any party can identify an express rule compelling that result. The petitioner submits that a rulemaking record carrying the appearance problems described in Section 14, arising from the same prosecutorial and judicial apparatus prosecuting the case it discusses, in a manner that placed that case back before the public and generated the reaction now used against the person it concerns, presents exactly the kind of appearance this court's inherent authority over its own processes exists to address, and the petitioner requests that the court exercise that authority accordingly, whether by declining to adopt either petition, by dismissing him, or by such other disposition as the court deems appropriate to that end. 18. The task force petition confirms rather than answers this petition's concerns. The task force petition does not merely continue R-2531's approach, it extends it substantially, in ways that illustrate precisely the concerns this petition raises. The petitioner addresses 4 specific features of the task force petition directly. First, the pre-planning requirement. The task force petition would require a person seeking to use a recording device to submit a request, generally 5 court days before a non-trial proceeding, or, as soon as reasonably possible, for expedited matters, after which the court must notify the parties. The parties may object by a court-set deadline, and the court then rules on the request under an 8-factor test, with that ruling reviewable only by special action, a discretionary and rarely granted form of review. The petitioner takes the position that this is precisely the model this petition asks the court to invert. A public institution's basic operations should not require advance scheduling, an opportunity for opposition, and a discretionary ruling before a citizen may observe them, any more than a public library requires a membership fee, an application, and a hearing before a patron may read a book on its shelves. The correct default for a public record maintained by a public institution is availability, not a permission process with built-in opportunities for delay, denial, and only limited appellate recourse. Second, the expanded definition of a recording device. The task force petition would define a recording device to include any device including a cell phone, camera, apparatus, or application, app, and would specifically provide that a recording device includes a device that uses artificial intelligence. Read together with the new sanctions provision discussed below, this would place the petitioner's own use of AI-assisted drafting and analysis tools the petitioner has used throughout this litigation, as reflected in the certificates accompanying his filings in State of Arizona version. Jensen, within the scope of a rule requiring advance judicial approval merely to use them in connection with a proceeding, on pain of contempt or criminal charges for non-compliance. The petitioner submits that a rule broad enough to potentially require advance court permission before a self-represented litigant may use an AI tool to help prepare for or process a hearing illustrates, in concrete terms, the disconnect between the judicial branch's rulemaking and the technological reality discussed in Section X above. Third, the new sanctions provision. Current Rule 122 contains no express sanction for unauthorized use of a recording device. The task force petition would add 1. A person who uses a recording device without prior approval is in violation of this rule and is subject to sanctions, including contempt of court or criminal charges. This is not a marginal or technical change. It converts a rule presently enforced, if at all, through a request and denial process into one carrying the same category of criminal exposure already discussed in Sections 11 and 16 above in connection with elastic public order statutes, and does so for conduct as ordinary as recording a hearing on a cell phone, or, per the expanded definition, using an AI application in connection with one. Fourth, the task force petition's reliance on DECA version. Bails, number, CV160287 PHXSRBD. Arizona. Feb. 28, 2017, and Peltz version. Roberts, number, CV2300094 Tuck RCCD. Arizona. November 9, 2023, for the proposition that no unfettered or clearly established constitutional right to record court proceedings exists. The petitioner does not dispute that characterization of those decisions, but submits that it does not do the work the task force petition asks of it. The absence of a judicially compelled right to record does not mean this court's own rulemaking authority cannot grant, by rule, a presumption of recording and broadcast access exceeding what the federal Constitution independently requires, which is precisely the relationship between Article 2, Section 11 of the Arizona Constitution and the federal open courts doctrine already discussed in Section 3 above. That Arizona's courts are not constitutionally compelled to adopt this petition's proposed presumption is not a reason to decline it. It is simply confirmation that adopting it is a matter of this court's discretion and judgment, which is exactly the discretion and judgment this petition asks the court to exercise. 19. Proposed rule text. The petitioner proposes that Rule 122 be restructured along the following lines. The petitioner recognizes that final rule text should be reconciled against the then current text of Rule 122 and Rule 122.1 prior to adoption, and respectfully requests the opportunity to submit refined proposed text, or to confer with the task force, prior to any final recommendation to the court. A. Presumption of public coverage. Public judicial proceedings in all courts of this state are presumptively subject to public coverage as provided in subsections B and C, without requirement of advance request by any member of the public, press, or party. B. Institutional coverage. Every public proceeding shall ordinarily be captured and made available through an official, court-controlled recording or streaming system, consistent with subsection K. A court may not deny a request for personal recording under subsection C, on the ground that official coverage renders it unnecessary, unless the official recording of that proceeding is complete, unredacted except as permitted under this rule, and made publicly available within the time required by subsection K. C. Personal recording. A member of the public, press, or party may separately operate a personal recording device during a public proceeding, subject only to reasonable, content-neutral rules addressing device placement, noise, courtroom order, and the number of devices operating simultaneously. Personal recording under this subsection is not a substitute for, and does not relieve the court of, the obligation to maintain official coverage under subsection B. D. Live, delayed, and archival transmission distinguished. This rule distinguishes among 1. Live transmission, meaning contemporaneous public broadcast or streaming of a proceeding as it occurs. 2. Delayed transmission, meaning public release of a recording after a specified interval following the proceeding. 3. Permanent archive, meaning the recording made publicly available under subsection K, following any proceeding. 4. Temporary withholding, meaning suspension of public release pending resolution of a specific, identified issue. 5. Redaction, meaning removal of a discrete, identified segment or portion of a recording. And 6. Removal after publication, meaning withdrawal of a previously released recording upon later discovered cause. A court that restricts live transmission under subsection E shall specify which of these mechanisms applies and for what duration, and shall not, absent the findings required by subsection E, withhold delayed transmission or permanent archival access solely because live transmission was restricted. E. Restriction or closure, standard. A court may restrict or prohibit coverage of a proceeding or a portion of it only upon specific, on the record findings made prior to or during the proceeding, satisfying each of the following. 1. The party seeking restriction bears the burden of justifying it. 2. The findings must be supported by clear and convincing evidence of a credible, particularized risk to an enumerated interest under subsection E. 5, and not by generalized concern, embarrassment, or inconvenience. 3. The restriction must be narrowly tailored to the specific risk identified, and the court must find that no less restrictive alternative under subsection H is adequate to address it. 4. The findings must state the scope of the restriction, which portion of the proceeding, and which mechanism under subsection D applies, and its duration, including any date or condition upon which the restriction will be reconsidered or lifted. 5. Interests that may support restriction under this subsection include a. The right of a party to a fair trial. B. The safety of a party, witness, victim, or juror, where a credible, particularized risk is shown. C. The confidentiality of a proceeding or category of information protected under subsection F. Or D. Another interest of comparable constitutional or statutory weight, specifically identified on the record. F. Confidential and legally protected proceedings unaffected. This rule does not convert a proceeding or category of information that is confidential under existing law into a public proceeding or public record. Nothing in this rule alters the confidentiality of, among other things, sealed proceedings, grand jury matters, adoption proceedings, juvenile proceedings and records to the extent confidential under existing law, medical or mental health proceedings confidential by statute, protected addresses and other information protected under applicable address confidentiality law, trade secrets and other information subject to protective order, privileged communications inadvertently disclosed in open court, to the extent a court orders such disclosure struck or redacted, sidebar and bench conferences, juror identifying information not otherwise authorized for disclosure under subsection G, and any proceeding or portion of a proceeding closed under an existing constitutional or statutory standard independent of this rule. G. Jurors. Coverage of voir dire is subject to subsection E. A court may, on request of a prospective or seated juror or on its own motion, decline to display a juror's name or image, or may authorize visual masking of a juror while preserving audio coverage. Jury deliberations are categorically excluded from coverage under this rule. H. Witnesses and victims, narrowly tailored alternatives. Before restricting coverage of a proceeding in its entirety under subsection E, a court shall consider whether a narrower alternative is adequate to address the risk identified, including obscuring a witness's or victim's face while preserving audio and the remainder of the visual record, altering the camera angle, redacting a home address or other identifying detail, delaying publication of the affected segment under subsection D, providing audio-only coverage of the affected testimony, protective measures specific to a minor witness or victim, protective measures specific to a confidential informant, or excluding only the discrete segment of the proceeding presenting the identified risk, rather than the proceeding as a whole. I. Emergency interruption. If protected information is unexpectedly disclosed during a live transmission, the presiding judge may immediately interrupt or suspend the transmission. Within a reasonable time following any such interruption, the court shall make findings on the record identifying the information at issue and the basis for interruption, review the interrupted segment, publish, under subsection K, all portions of the segment not subject to a restriction properly entered under subsection E, and provide a written or oral explanation of the interruption sufficient for review under subsection J. J. Review. A party, member of the press, or member of the public aggrieved by a restriction entered under subsection E, or an interruption under subsection I, may seek expedited review by special action or such other expedited mechanism as the presiding court or the Court of Appeals may provide. The recording or segment at issue shall be preserved under seal pending review. If a restriction is later determined to have been improperly entered, the previously restricted material shall be published under subsection K, promptly upon that determination. K. Public archival, retention and integrity. Recordings of proceedings conducted under this rule, except material properly restricted under subsection E, or confidential under subsection F, shall be made publicly available without cost for access, through the administrative office of the courts or the applicable court's own infrastructure, consistent with the practice currently maintained by this court for its own oral arguments, subject to the following. 1. Recordings shall be retained permanently unless sealed by court order. 2. Recordings constitute official records of the proceeding for purposes of preservation and authenticity, without displacing the official transcript or minute entry where one exists. 3. Recordings shall be made available in a downloadable format in addition to any stream-only access, where technically feasible. 4. Recordings shall be linked to the corresponding docket entry by timestamp. 5. Courts are encouraged, but not required absent separate order, to provide captioning and indexing of recordings as resources permit. 6. A recording later found to be corrupted or incomplete shall be noted as such in the public record. The corruption or incompleteness of a recording does not, standing alone, provide grounds to withhold an otherwise complete portion of the record. 7. Correction of metadata associated with a published recording, or deletion of a published recording, requires a court order stating the basis for the correction or deletion. L. Implementation. Courts shall, to the extent practicable using audiovisual infrastructure already in use for remote hearing purposes, implement this rule without requiring the procurement of new hardware, except where existing infrastructure is demonstrably inadequate to produce a public archival record consistent with subsection K. A court asserting that implementation is not practicable shall, within 90 days of the effective date of this rule, publish a written implementation plan identifying the specific technical, staffing, or resource obstacle, and either a target date for implementation or a request to the administrative office of the courts for a time-limited waiver. A waiver under this subsection is renewable only upon an updated showing and may not be renewed on the basis of the same obstacle previously identified without a showing of efforts made to resolve it. XX. Conclusion. Rezoner's courts derive their authority from the appearance of just authority, sustained through the public's ongoing capacity to observe what is done in its name, not from the correctness of outcomes measured after the fact, and not from the public's willingness to take that correctness on faith. Offutt requires no less. That capacity has been steadily eroded, not by any single decision, but by the accumulated effect of a rule structure built for a technological and social era that no longer exists, applied against a public that can no longer afford, as a practical matter, to exercise the access the rule nominally preserves. The infrastructure necessary to correct this erosion is already installed and already in daily use by this court and the courts of this state. What remains is the judgment to extend it, and to place the burden of justifying invisibility on the institution asking to be trusted, rather than on the public asking to see. Wherefore, the petitioner respectfully requests that this court sad face 1. Adopt the amendments proposed herein, or such modified version as the court deems appropriate. 2. Open this petition for public comment pursuant to Rule 28, c. Rules of the Supreme Court of Arizona, concurrently with its consideration of R-25-0031 and the Task Force petition. 3. Grant expedited consideration of this petition, for the reasons stated in Section 17 above, so that it may be considered before R-25-0031 and the Task Force petition are finally resolved. And 4. Exercise its inherent authority over its own rulemaking processes to decline to adopt, or to dismiss, R-25-0031 and the Task Force petition, for the reasons stated in Sections 14, 17, and 18 above, or grant such other relief as the Court deems just and appropriate. Respectfully submitted this 2nd day of August, 2026. Jason Adam Jensen, Petitioner.
Well, that took quite a while. We have some comments. Great work, boss. To say what Lane Myers is doing in his journalism is garbage. He's done it in many aspects of life. Okay, well, I mean, it is journalism. You may not like it, you may not appreciate it, but it doesn't change what it is. It's journalism because he's finding information and he's reporting on it. That's journalism. He acts as a pest. He threatens people saying, I am a federal prosecutor. Yeah, I don't know about all that. He thinks society is going to tolerate harassing the wife of a prosecutor. What kind of beta move is that? Well, I cover that quite extensively, and apparently the only thing that changes here is the prosecutor part. Because, like I keep saying, any other time there's a story, they always go to the wife and the relatives and ask their perspective and stuff. Like, well, like, here we go. Why did the media ask Melinda Gates for comments when Bill was tied to Epstein Island? Exactly my point. Exactly. Why does the video here seem so far away? Oh. I guess I just fast forwarded to here. Anyways, I thought I would look at some of this information, because basically if you end the stream too quickly, I think it ends up cutting it off. But that is the petition that I made to the Supreme